The broadcast is now starting. All attendees are in listen-only mode.
Welcome, everyone. My name is Andrew Capehart. I'm the Director of the Adult Protective Services Technical Assistance Resource Center, and welcome to our event, APS Regulations Q&A with ACL. We have several presenters with us from the ACL today, and I'll introduce them shortly. Next slide. A little bit about the APS TARC if you're not familiar. The mission of the APS TARC is to enhance the effectiveness of APS programs by working with partners on use of data and analytics, applying research and evaluation to practice, encouraging the use of innovative practices and strategies, and providing APS programs individualized technical assistance. Basically, we're here to help you in any way that we possibly can. And yes, that includes assistance with the regulations and implementing them. Just reach out to us using the contact information at the end of the presentation at any time. We'd be happy to help you. Next slide. On to a little bit of housekeeping. Please use your computer, speakers, or telephone to access audio for this webinar. Make sure your speaker volume is adjusted to the desired volume. If you're joining by phone, make sure to enter your audio PIN, please. If you experience any audio problems or connection issues during the presentation, what we recommend is that you log out and log back in. That often fixes many of the problems. But if you are having issues, send us a question. We'll do our best to help you troubleshoot what the issues are. Next slide. This webinar is being recorded, and all registrants will receive an email when the recording is posted to the APS TARC YouTube channel, so we'll let you know when it's online. The handouts and slides are available now in the handout section of your GoToWebinar control panel. They're labeled slides, and it's a PDF file, so you can click on those, open them, and download them at any time. There's a few links in this presentation, so you might want to download those so you can access those links when we go over them here in a little bit. Next slide. And at this time, I'd like to introduce Carrie Benson, the Deputy Assistant Secretary for Aging at the Administration on Aging, Administration for Community Living. She's going to make a few remarks for us. So Carrie, welcome.
Thank you, Andy, and it's great to be here with you all. I am so excited to be a part of the ACL team and a part of our efforts in working with and supporting all of you in implementing the new Adult Protective Services regulations. This is an incredibly important and exciting time for all of us, and we are here and ready and available and so interested to be able to continue our work with all of you at the state and local levels and implementing the new regulations and really moving forward our national adult protective services systems. And so I'm going to turn it over here pretty quickly to the ACL team that is leading up our efforts on the adult protective services program overall, but also implementation of the regulations. But just know that we are really preparing and working closely with Andy and his team at the APS TARC to provide you all with ongoing technical assistance and training and support. So just know we're here with you, working with you to make these regulations a reality. We are very pleased that we have time to do this, right? So it doesn't all have to happen at once. We've got time and what I think of as maybe a glide path, although maybe with a few bumps in the way, along the way. But we are really, going to be working through this together over the next 4 years and then from then on with you. So definitely call on us, as Andy said, call on the TARC as needed. We are here for you to provide you with the technical assistance, and we're excited to really begin that process with the webinar here today. So with that, I will just end my remarks and we'll be listening and learning with you all as we go, and excited to continue our work together. So thank you. And we'll go to the next slide. Thanks, Andy.
Thanks, Carrie. Glad you could be with us today. I'll go ahead and introduce our other two speakers who will do the bulk of the talking today. First off, we have Stephanie Whittier Eliason. She's the Acting Director of the Office of Elder Justice and Adult Protective Services at the Administration for Community Living. And we also have Erin Key. She's an aging program specialist, also at the Office of Elder Justice and Adult Protective Services, also at the Administration for Community Living. So I'll be turning things over to them in just a moment. Next slide. Just a little bit of information on the final rule or the regulations. These new regulations promote high quality adult protective services and will improve consistency across all states. They establish a set of standards for the operation of APS programs that all programs must meet. There's a recorded webinar that took place last week, I believe. It's been posted to the ACL YouTube channel, and the link is here. Again, you can download the slides anytime you'd like and access these links, but you're welcome to watch that, which goes into detail about the regulations and about what each section covers. So we recommend taking a look at that if you weren't able to attend that webinar. And then also, if you'd like more information, you can visit the other website here at this last bullet, acl.gov/APS rule, or you can go to the APS TARC website, apstarc.acl.gov/regulations. Both of those will get you to the same place with lots of good information about the regulations, including a plain language piece that will go over all of the details of the regulations. So next slide. And now a little bit about how our Q&A will work. You can ask questions at any time of our presenters by typing them in the questions box, questions/chat box. Just type your questions in. You don't have to wait until we're done or when we start here in a moment taking questions. You can type them at any time. Please keep your typed questions brief so that we can relay them to the speakers in the audience easily. Questions will be addressed in the order that they are received. And please try to limit your focus to questions about the regulations, since that's the topic of today's webinar. We ask that you ask questions about the regulations specifically. So thanks so much for that. Next slide. And I think at this point, I will turn things over to Erin Key.
Thank you, Andy. We are so glad that you're joining us today and are excited to answer your questions about the new APS rule. In order to give our conversation some structure today, we ask that you address which section of the rule you are asking your question about in the question when you submit it in the question box. So for example, if you want to ask about eligibility for funding, if you can use the 3 digits at the end, so 400 for eligibility of funding, 401 for definitions, 402 for program administration, 403 for APS response, 404 for conflict of interest, 405 for accepting reports, 406 for coordination with other entities, and 407 for program performance, and finally 408 for state plans. This will allow us to kind of group the questions together and keep us on track for topics. So Andy, do we have the first questions?
We certainly do. Our first question comes from section 401, definitions. And I'll relay the question now. Our definitions for abuse and sexual abuse only include abuse and sexual abuse by a caregiver. Will we need to change our definitions to be considered compliant with the regs? And I'll repeat that question. Our definitions for abuse and sexual abuse only include abuse and sexual abuse by a caregiver. Will we need to change our definition to be considered compliant with the regulations?
Shall I take that one? Yes, okay. Thank you for the question. That is a question we've been getting a lot, actually. So as is described, so the first thing I want to do is tell everyone that a lot of what you're going to hear me talk about today, or Erin or Carrie, if she is also answering questions, we will first refer you back and ourselves back to both the preamble and the background in the reg, as well as the regulation text. That will always be the best place for folks to go when trying to understand what applies, what does this mean, what do I have to do? And in that background, we do talk a lot about our rationale for all of the provisions that are included in the rule. So the definitions in the final rule, it does say in the background and preamble that states are not required to adopt the definitions verbatim. that when it comes to assessing how aligned states are with the definition, we will be looking to see if the state's definition captures what is intended in the definitions that we have in the regulations.
Great, thank you.
There was a lot of talking before, short answers. Is there a follow-up on that?
Not that I see. Yeah, I think we can probably move on to the next question, which is also about Section 401. I see that definitions like inconclusive, quote unquote, have been removed. However, I couldn't find what term was replacing it. Again, I see that definitions like inconclusive has been removed. However, I couldn't find what term was replacing it.
Right. So we received a lot of input from APS programs related to the terms we used to discuss findings, whether the finding is substantiated or conclusive, inconclusive, et cetera. So the comments indicated that if we held fast to those terms that we put forth, that some states might have to change their state statute to become compliant. And for the purposes of this reg, it wasn't the goal isn't that all states use these terms. The goal is that there is a finding. A finding is documented consistently in each case, and that the state establish policies and procedures that very clearly articulate the terms that their state and their local APS programs will use to describe what the finding is in an APS investigation or an APS case. So we have removed those terms, inconclusive, substantiated, and unsubstantiated, and in its place, we indicate that states have to establish how they're going to define what a finding is and what those terms are, and they're going to assure that all APS programs in the state use those terms in the same way.
Great, thank you, Stephanie. We have a question about Section 404. How does APS petitioning for guardianship for older adults at risk as part of connecting to services qualify as a conflict of interest? Again, how does APS petitioning for guardianship for adults at risk as part of connecting to services qualify as a conflict of interest?
I'm writing this question down. Certainly. This one might be one that we answer in writing, but I want to make sure that we are not misunderstanding what is being asked. We have petitioning for guardianship qualify as a conflict. Okay.
Yes, this person said it's not clear how APS acting as a guardian is a conflict.
Okay, we can have a follow-up conversation with that. I would also refer the questioner to the preamble and the background where we talk about the guardianship and APS and as well person directedness. If their question about APS possibly being a conflict of interest in petitioning for guardianship, if their question is not answered after they read the detailed comment and response section, as well as our other justification, they can certainly follow up directly with ACL, and we'll be happy to answer that in writing, in an FAQ probably.
Great. Thanks, Stephanie.
May I pause real quick, Andy?
Sure.
One of the other things that we had intended to share and make clear is that one of the other purposes of this webinar and this session is so that the ACL team and the APS TARC, we can identify areas where states might want more information, technical assistance, or training And so this question about guardianship reminded me that I don't know if we said that at the beginning, but I wanted to assure states that even if you don't have a question, if there's something that you would like additional training on, you can put that in the chat too.
Great. And this person did send a follow-up comment saying it is clear how acting as a guardian is a conflict of interest. I think I may have read that wrong. I think they were confused about whether it was clear or not. They're saying it is clear that acting as a guardian is a conflict of interest. So they wanted to elaborate on that. So we'll follow up on that in writing. Here's a question about 400 eligibility for funding. It's a brief question. Who is eligible for the funding?
So again, I will refer you to that section in the rule. This one's going to be down towards the bottom of the entire printed APS rule, and it's pretty short. It is the state entity that is responsible for adult protective services. If they accept the Elder Justice Act funding under Section 2042, then they would need to abide by the regulations. And the compliance date is May 8, 2028. So funding that is received today, funding that is received in this fiscal year, is not contingent upon compliance with the rule.
Great, thank you. Another question, I'm not sure which section this might fit under, but the question is, do these changes require that all regulations set forth for APS must also be implemented into the Older Americans Act Elder Abuse Prevention and Awareness programs? Again, do these changes require that all regulations set forth for APS must also be implemented into Older Americans Act Elder Abuse Prevention and Awareness programs?
I think I understand the question, and the answer would be no, that these regulations are applicable to those who receive Elder Justice Act funding for adult protective services. So it does not have bearing on Older Americans Act funding or Older Americans Act requirements, except where there is a requirement to partner or coordinate.
Great, thank you. Another question, in our state, we are regionally based to cover multiple counties. We do not have workers in all of our counties to comply with the 24-hour response time due to distance. We will need additional workers and funding to comply. I guess that's more of a comment than a question. But again, our state, we're regionally based, cover multiple counties, don't have workers in all of our counties to comply with the 24-hour response time. They'll need additional workers and funding to comply. Any comments?
Yes, I would actually characterize that as a misunderstanding of what's required in the regulation. I would refer the questioner back to both the background and the preamble, section 4.1324.403 for APS response, and as well 402 for program administration. The requirement in the language of the reg is not that it is APS itself that has the 24-hour response. It is that there is a process and a procedure for ensuring that there is face-to-face contact with the potential victim. If it's deemed an emergency within 24 hours, it does not need to be APS. And we outline we give examples of a number of different partner agencies that could serve to fill that responsibility for having face-to-face contact within 24 hours, such as other community-based social services or emergency response, like an ambulance. Law enforcement could be another entity that could serve that purpose. So we have clarified that in the rule.
Thank you. Moving on to our next question. This is section 401. I'm going to truncate this question just a little bit because it's kind of lengthy. We are trying to wrap our heads around our data collection, and our definitions are worded differently than the federal regulations. Is there a sense of what data will need to be collected? Is it similar to NAMers? Again, we are trying to wrap our heads around the data collection, and our definitions are worded differently than the federal regulations. Is there a sense of what data will need to be collected? Is it similar to NAMers data?
That's an excellent question. So NAMers is best to be conceived as a public health surveillance data system. That is not changing. That is a way for us as a nation to understand incidence and prevalence of adult maltreatment as it comes to the attention of APS. So it is about clients, perpetrators, to the extent that we can have that information. And then there is some information in NAMers about state APS programs that is intended solely to help individuals who are looking at the data understand how to interpret that data. For the regulation, the data that's going to be collected is going to be performance data. So that's really going to be getting at how well does the APS program perform, serve their clients. We don't have data elements already determined on that. The process will follow the typical Paperwork Reduction Act process of public comment, ACL engaging with stakeholders, asking about what performance data makes sense, coming up with a proposal, putting it out for public comment, getting that public comment, and going through that refinement process. So that is not something that we need to worry about at the moment. And all the states will have an opportunity to engage fully with us as we are working on crafting those performance data elements.
Great. Thank you, Stephanie. Another question from section 400 related to bifurcated systems. If a state has an APS population determined by state code to cover 18 and under with a disability, but older adult services are provided by the Older Americans Act and not state law regulations, are both APS and the Elder Adult Protective Services subject to their APS regulations to qualify for funding? So in a nutshell, bifurcated systems, is it, are both systems under the regulations, beholden to the regulations?
So an easier way to look at this is that if the entity is going to receive Elder Justice Act funding to provide adult protective services, then the regulations apply to them. So in a bifurcated state where you have, I'm going to make this up, one agency serves 18 to 59 for protective services, and one agency serves 60 and over for protective services. If both entities want to receive a allotment or money from the Elder Justice Act, then they both have to be in compliance with the regulations. If only one entity is going to receive the funding, then it doesn't apply to the other entity. It's better to look at it, it's clearer if you look at it in terms of, am I going to accept the Elder Justice Act APS funding?
Great. That makes sense. Thank you, Stephanie. Here's a brief question. I'm not sure what section it belongs to, but how will information be submitted to ACL to demonstrate whether or not a state is in compliance? Again, how will information be submitted to ACL to demonstrate whether or not a state is in compliance?
So I'm going to give Carrie an opportunity to add to whatever I say. However, so one, that hasn't been determined at this moment, the process and the procedure for doing that, but we are going to follow what is done with the Older Americans Act in terms of providing information. And Carrie, I don't know if that process has been fully fleshed out yet, or if you wanted to share anything. Hint?
Yeah, absolutely, Stephanie. Thank you. And I will share just a couple things about this because we are, as of course many of you are well aware that the Older Americans Act final rule was issued not too long before the APS final rule. And so in my first 3 months on the job here at ACL, I've been jumping in into the thick of us implementing the final rules and really working alongside all of you to do so. And we are committed to taking a very consistent approach and a very supportive approach to work with all of you and support your work to implement all of the different components of the final rule. And so to that end, we will be following a consistent process. And, with the APS final rule, we get such a huge benefit of working with Andy and his team at the APS TARC to be able to provide you all with regular trainings and technical assistance. And then on your end of the deal for the states we will be working with, we'll be going through a process with you of working to understand your questions and concerns, providing one-on-one technical assistance. And this will really be kind of an outgrowth of the state plan development and submittal process that many of you, if not all of you, are familiar with already, that you've been going through with the different APS funding you've received, and that development and implementation of those plans. I will say, as we look forward to, and of course with the APS rule, we've got a longer time horizon for this, but as we look towards the compliance date, out in 2028, we are thinking about what this looks like, for if you do have additional items that you need to work on, not quite compliant with yet, not fully implemented, I should say, even more probably accurately, in how we are approaching this. We will be entering into corrective action plans to work with you and track that. But what I will share is that as we are moving forward in our implementation efforts, we're really thinking of those even more so as regulatory transition plans. That's what we've been starting to call them more and more, and really I hope reflects the approach that we intend to take in supporting you all. So there will be definitely more to come. I know you'll have a reminder at the end of this webinar too to really be sure to be checking our website, be checking the APS TARC web resources as well for additional information and future webinars. But we're really going to take quite a methodical approach in working towards the different areas.
Great. Thank you, Stephanie. Thank you, Carrie. Moving on to our next question from section 401. This one's a bit long, so I'll have to probably read it twice. Will ACL be providing further guidance to states for alignment around the definitions in the APS rule and the Home and Community-Based Services Access Rule definition of incidents that are reportable under the Access Rule? And they go on to say, but not APS rule, i.e. consulting with poison control or unanticipated death that is not suspected maltreatment, and 403, when the state Medicaid agency has responsibility for investigation of maltreatment incidents, when APS also has responsibility but is not meeting timelines. So would you like for me to repeat that? Do you get the gist of it, Stephanie?
No, I got the gist of
Great.
it. So yes, thank you. Excellent question. And that actually goes beyond, as you noted, the definitions to the coordination with other entities. We do plan, that is one of the items that's on our list of technical assistance, a fact sheet or some sort of information to the state, and that is related to the coordination with the state Medicaid agencies and coordination with other entities for response. The rule states that the state APS program must establish and clearly state the conditions, the settings, the circumstances where the state APS program has responsibility for investigation, and not that it's their responsibility to set forth where the responsibility for everybody else, but at least to make clear to the public and to other agencies what their role is. And again, as I said, this is an area that we know there are a lot of questions, and we definitely have that tagged as needing more follow-up to help states understand what the intent is and how they can implement it.
Great. Thank you, Stephanie, and thank you for the person who asked that question. Another one, which is regarding state plans, so section 408, it's a short one. Will a template be sent out to states regarding the state plan?
Absolutely. Erin, do you want to say anything about this, or do you want me to take it?
No, I can jump in. We will definitely be sending out guidance about your state plans, and we will be working with you extensively on how to complete your state plans. But I want to make a plug right now for our June 4th webinar, which is going to be about updating your operational plans. And during that webinar, we're going to briefly touch on how your current operational plans are going to serve as a basis for your state plans, and how we're going to be working with you over the 4-year period you have to come into compliance for using your operational plans to transition into a state plan. So we will be giving lots of guidance about that, and here to help for all your questions.
And I'm going to put the link to register for that webinar right now in chat, because I was hunting it down while you were talking, Erin. Here's the link to the operational plan webinar, and that is on June 4th. And that is in chat right now. So if you have not registered for that, I highly recommend you go and sign up for that, because we'd be more than happy to help you. Yeah, put that on. So thanks, Erin. Next question. I'm not sure if this is in the regulations or not, but you can tell me whether it is or not. Does the perpetrator have to be named? If so, what are the protocols for fair hearing rights? Again, does the perpetrator have to be named? If so, what are the protocols for fair hearing rights?
We do not. We talk about perpetrator in the rule. We, in terms of maltreatment, it's at a minimum a dyad. We're not, and the way we've defined it, we've taken self-neglect out of the definition of adult maltreatment, defined that separately. So, so yes, perpetrator is discussed and addressed and exists. We do not have any requirements for anything related to the perpetrator. APS is I'm speaking to the choir here. APS is a social service-based program, and their target is their target audience. The people they serve are those who have experienced abuse. So we cannot then extend to require something of APS, of an entity that they don't necessarily serve. So there's nothing in the rule related to what an APS program must do regarding perpetrators, other than identify in their policies and procedures types of perpetrators, types of circumstances where they will investigate or be involved.
Great. Thank you, Stephanie. Moving on, this is a two-part question. Part one is for section 405, accepting reports. Adds the requirement that APS must only inform the reporter if a case has been opened with the prior consent of the adult. It's hard to imagine how this works when the identity of the reporting party is confidential. Can you clarify? And again, I'll repeat that. It adds the requirement that APS must only inform the reporter if a case has been opened with the prior consent of the adult. It's hard to imagine how this works when the identity of the reporting party is confidential. Can you clarify?
Yes, that's an excellent question. I can begin to clarify, but I can also say that this is another area that we've identified where states have asked for examples and how this would work in practice. And so we will be following up with more information. However, an example that was shared with us is, for instance, in the course of the investigation or the interaction, excuse me, with using the word. I understand that it could mean different things for different states. So in the course of an APS interaction with a APS client, for example, there could be a upfront request for permission from the client to share or receive information in a number of different ways or with a number of different entities. Not a blanket, release of information. I know there's issues with that, and I agree there being issues sometimes. But for instance, if you are having a client sign a release of information with specific entities, one approach could be having the client also agree to release some information to, a mandated reporter. That's just one approach. It's just an example. We definitely hear from states and some other advocates that this is a question of a little bit, there's some confusion around it, and it is an area we've identified for additional follow-up. So thank you.
Thanks, Stephanie. And the second part of that question, does this impact record releases to parties who currently are authorized to receive APS records, such as law enforcement agencies or for criminal investigations? So again, does this impact record releases to parties who currently are authorized to receive?
No. So we clearly state in the regulation that all of this is pursuant to state information release and privacy and confidentiality laws. So this does not circumvent those. So whatever is allowable within the state, we are not saying they need to change. They will need to explore it and to make sure that as they're implementing the rule, they are also being consistent with their state policies and laws.
Great.
Does that answer the question? I'm looking at a couple of my.
I would think so, but as a person who asked that question, feel free to elaborate in the question box if you feel like you didn't get the answer from that, please. Next one, I'm not sure which section this, I think it's 406. It's a brief question. What if we don't get cooperation from partners?
So APS is only in the rule. APS is only being required to establish the policies and the procedures. And of course, this could be in any one of these 8, sections getting cooperation. You are not going to be held responsible for whether another entity participates with you or shares information with you, as an example. The requirement is that APS is clear about how do they do business, what are their policies and procedures, and being transparent about those.
Great. Thank you, Stephanie. Next question. I'm not sure what section is in. This might actually not be in the regulations, but maybe you can provide some sort of insight into it. But APS needs a federal data platform that states utilize for their work. CCWIS, Comprehensive Child Welfare System, was established in the mid-90s. Is there a plan for a similar system for APS? So the question again, APS needs a federal data platform, something like CCWIS, people who are familiar with that. Is there a plan for a similar system for APS?
We have not approached that yet. So I guess the answer is no. We don't have a plan yet. A decision has not been made about doing something as comprehensive as that.
Great, thank you. Let's see. This one is regarding state plans. So Section 408. Will the state plan be required to cover the full APS program, or just those portions funded by federal funds? So again, will the state be required to cover the full APS program, or just the portions of the program covered by federal funds?
The intent is that the state plan cover all of the APS programs and entities within the state. We definitely will be providing technical assistance, and if this is getting confusing, please states let us know, and we will work to provide more clarity.
Great, thank you. This next one's slightly long, so I'll read it twice like the other ones I have. Our state is one of the few that operate out of the prosecutor's office. We recently learned that Indiana prosecutors will not renew the contract next year due to lack of funding. Will the regulations and funding clarify the way our state will move forward with APS structure? So again, this person's state, the APS programs located within prosecutors' offices. Will the regulations and funding clarify the way our state will move forward with APS structure?
I'm sorry, is the word clarify, is that what I'm hearing? Will the regulations clarify?
Will the regulations and funding clarify the way our state will move forward with their APS structure?
That's an interesting way to word the question. And I don't know what the right answer. Will it clarify? Well, I don't really know what it is in the state. So my response to that is depends. Honestly, the rules identify who is the state APS agency, to whom the funding, to whom the regs apply, and then for the program, the requirements and the federal regulations for the program. And those are not all of the requirements. We defer to states to identify for that state who is going to be that state designated entity to provide adult protective services. We don't have a requirement for it to be housed in any particular office or department. So again, it is a baseline of what the APS program should have in terms of providing guidance. The answer then would be yes. It will provide that kind of direction, but it won't give them the answer as to which state office ought to house the state APS program.
Great. Thank you. And this is just a plug to keep your questions coming. We have one comment and one question left. And we have about 18 minutes left in the webinar. So if you have additional questions, go ahead and type them in now and we will get to them shortly. So our next question, let's see. Oh, no, sorry, we already answered that one. So actually we have one comment left. I think a previous response might have answered my question, but it's important to know that in the stakeholder call last week, there was different information about bifurcated states. So it seems there's conflicting messaging between these two sessions. So just a comment that this person was confused about a comment last week with bifurcated states and today. So maybe a call for clarification.
So I would refer the questioner to the regulations specifically. We have discussed the circumstances around bifurcated states in the preamble and the background. So that is what stands. I could say whatever, and it could be very wrong, but it's really the reg that applies. I'm just giving an example. That's always the best place to go first, is to the regulation, to the background, and to the preamble. If they'd like to restate the question here, we can have it for the record so we can be sure to look at it and maybe add that one to our FAQs.
And the full text of the regulations.
Not that we'll read it and answer it, but.
Right. The full text of the regulations can be found on either the APS TARC site or a link to it on the APS TARC site or the ACL site. Again, you can download the slides from today and you'll get those links in there. Go to the Federal Register notice. Is that correct, Stephanie, to get the full text of the regulation?
Yes.
Yep, and it's the last several pages and you can read verbatim what's in there. So highly recommended if you haven't done that to do that. That was our last typed question. So maybe we'll give a minute for people to come up with any other interesting questions they have. I think this was alluded to earlier, but don't know if we said it or not. Isn't there a time frame for how many years the states have before they can implement these regulations?
It is not before they can implement. It is that the compliance date is May 8, 2028. So we would expect all states to either be in full compliance or to have worked with ACL on additional time to reach full compliance.
Great. And you can contact the APS TARC for help with any of the implementation of the regulations. We're here to help you, and we're planning on providing a lot of TA blogs, webinars, briefs, etc., on the different topics from the regulations over the coming years. So
Andy, can we summarize real quick while we're waiting to see if more people have some questions? We got a lot of questions around eligibility for funding and the bifurcated states, definitions, coordination with other entities. Do we have any? Are there other themes that we want to that had a lot of questions or comments? We want to make sure to note, and of course we'll go through the Q&A.
Certainly. Just
giving opportunity to folks to, if you have an issue that hasn't been or a section that hasn't been addressed yet, and it's something that's important to you, can you at least just send it as a comment? Doesn't have to be a question, and we'll include it in our list of topics.
Great. One comment or one question just came through. When should we expect one-to-one technical assistance specific to states from the APS TARC? Will there be outreach? So every state has a liaison with the APS TARC. You have a contact person with the APS TARC that's your go-to. You can talk to them at any time to get one-on-one technical assistance, and the same goes with the regulations. So your liaison should be reaching out to you to offer that assistance at any time. But in the meantime, you can reach out to them whenever you'd like as well. And yes, we'll be providing technical assistance for the regulations.
And we would like to add to that, if you have specific issues that you know that you're going to need one-on-one assistance with, let your TARC liaison, your APS TARC liaison know that. They will provide that information back to us. We want to make sure that we are as resourced as possible to provide that one-on-one TA, whether that is going to be from ACL staff, from APS TARC, or any number and combination thereof. So it isn't just go to your TARC liaison and that's all you're going to get. They're going to bring that information back to us. Yeah. And we are going to make sure that everybody has the technical assistance that they need to make sure that they're in compliance.
And a similar question, will there be a cost for technical assistance? So for the APS TARC, no, there will not be. Of course, we're serving all 56 states, District of Columbia, and territories. So we are spreading our help around with all the states, but no, if we provide technical assistance to you, there is no cost for that. That is something that.
And when yep, exactly. We fund the APS TARC to provide the technical assistance, and that's why it's important if you have a TA need or you think you will be having a TA need to let the TARC know. They're collecting that information and they're conveying that information to us. And we are able to plan the technical assistance around that. And I was reminded, and I apologize for forgetting, you all also have an ACL project officer that you have regular contact with, that you can, one, they'll be supporting you all, but two, you can also let them know that you're going to have a technical assistance need. And we're going to combine all of that information to make sure that we have a good cohesive plan moving forward.
And please do reach out to the APS TARC. Let me keep my job. I would appreciate that. Little job security would be great. If you can come to us as much as you possibly can, we would love that. So another person asked about where can you get the copy of the regulations or to read the regulations, and I'm going to put in chat the link that I mentioned earlier in the slides, the ACL website. This is where we recommend. You can also get that website from the handouts today, the slides. You can download them anytime, and those links are in the slides as well. A couple other questions have popped up. Let's see. Can you clarify the due dates for the state plan? Is it due 4 years after the regulations are final, June 2024, or when compliance is due by May 2028, or some other date? Preamble says state plans due 4 years after our regs are final. So again, can you clarify the due dates? Is it 4 years after the regulations are final, June 2024, or when the compliance is due by May 2028?
So Aaron, so we have two times that operational / state plans are due. Aaron, you want to take it from here?
Yes, I think there's a little bit of confusion in the question, but the regulations are effective on, let me just make sure I have the right date. So the regulations are effective on June 7th, 2024. The compliance date is May 8th, 2028. So your state plan will be due 4 years on the compliance date, May 8th, 2028. Operational plans are currently due on September 30th, 2024. So the operational plan and the state plan are different and have different due dates. Did I answer both of those, Andy?
Sorry, I muted myself. Instead of unmuting myself, yes, I think that you did. I'm pretty sure that you did. And those dates are in the Federal Register notice. Is that correct?
The operational plan date is not in the Federal Register notice because that is in, well, it is in a Federal Register notice, but it is in the Federal Register notice for the FY24 Elder Justice Act funding, not in the Federal Register notice for the final rule.
Great. That'd be a good topic for the FA.
And in the final rule, it says the date that the final rule was published, and it has identified the effective date is 30 days after publication, and the compliance date is 4 years after publication.
Great.
That's how those dates are derived.
A few other questions popping up. Will APS TARC provide workshops at the NAPSA conference to assist states with any questions regarding the new APS minimum standards? Will APS TARC provide workshops at the NAPSA conference to assist states with any questions regarding the new APS minimum standards? Excuse me. Right now, we do have several workshops planned. Go ahead.
Go ahead, Andy.
No, I was going to say,
I'm sorry.
We have several workshops planned. We're going to try and incorporate the regulations as best we can into those already planned workshops. We have time before the NAPSA conference to do a good job with incorporating those regulations. So short answer is yes. Of course, not everybody gets to attend NAPSA conference. So whatever assistance we provide at that conference will be available to anyone in the U.S. outside of that conference as well.
Thank you. And in addition to that, Carrie and the ACL team supporting Adult Protective Services do plan to attend the NAPSA conference this year, and we are looking for opportunities to engage with the state to talk about these regs again in more depth. And so you will be hearing more from us about that too.
Wonderful. Here is another question, which I believe comes from 400. Could this funding be used to contract assistance such as legal help? Again, could this funding be used to contract assistance such as legal help? I assume for clients.
So that question is better answered in writing because there's a couple of different references that we have to pull in. Essentially, the Elder Justice Act says that the fund must be used to provide adult protective services. So we have some FAQs that are public already related to how the Elder Justice Act funding has been authorized to be used to date, and we can respond to that question in writing. I think that's, yes, more fully.
I would also recommend sending that question to your project officer for your state if you have a question about that.
Thank you, Erin.
And since we're on the subject of project officers, the next question are project officers assigned only at the state level or also at the county level? Again, are POs, project officers, assigned only at the state level or also at the county level?
So ACL project officers are assigned at the state level.
Thank you. Another question about Section 408. what is the difference between the operational plan and the state APS plan? So again, what is the difference between the operational plan and the state APS plan?
It's a good question. And I am going to refer that person and others back to the preamble where we discussed the state plan. There were a number of questions for the NPRM commenters asking that exact question. And so we provided an explanation there. But essentially, sort of as a teaser before people go and read it, as Aaron had said earlier, we view the operational plan as the foundation of what will become a state plan that it will sort of convert. So we'll talk more about that in the webinar next week, as well as other technical assistance we'll provide, and you can read more about our explanation in the preamble.
Great. Another question is, how do I know who my TARC liaison is? And I can answer that question. So just like the project officers, the APS TARC works on the state level with the states. There are times we work with counties after the state, approves that and says it's okay to go, because usually the states will often want us to work with all the counties at one time on a statewide basis. So if you are with a state APS program, just reach out to the APS TARC. We'll make sure to put you in touch with your liaison. The contact information is on the final slide deck that you can download now, or you can write it down when we get to it at the end, which is coming up in just a couple minutes. But reach out to us. We can give you some more details on that if you're not familiar with who your TARC liaison is. And let's see, I think we probably have time for one more question before we wrap up. Does ACL plan to get rid of the APS voluntary guidelines, or will they become sort of a guidance document? So will ACL get rid of the APS voluntary guidelines, or will they become a sort of guidance document?
No. Again, if you reference the National Voluntary Consensus Guidelines, those are framed in terms of best practice based on what we know from the literature and APS practice on the ground. So they go far beyond the APS regulations. The APS regulation can be viewed as a baseline that is drawn significantly from the guidelines, but it in no way replaces the guidelines. We have not yet developed our plan for any further updates to the guidelines at this point, because based on our input from the last time, the number of years that folks thought it was appropriate to revisit those so that we have time for research to hit the journals and to be published. So that is still a little ways out, those conversations. But no, it is not intended, the regulation is not intended to replace the guidelines in any way.
Great. And with that, and just a couple minutes left, I think we can probably move on to the last slide in the slide deck, which has contact information for the APS TARC. Here's our website, our email address, and our socials so that you can follow us. Please do that. And get all the information that you can from the APS TARC. Are there any parting comments from our presenters, our panelists?
Erin, do you have any?
Had a hard time finding my mute button. Sorry, Erin, I did just want to thank everybody for joining us today. We had a really great group attending, a good number of folks, and we hope you found it helpful. I know we sure did, and please keep it coming as far as questions and topics for assistance, and we look forward to working with you in implementation of the final rule. Thank you.
Thanks so much. Well, thank you, Carrie, Erin, and Stephanie today for all this great information. It was nice to have state programs be able to ask some questions about the regulations. We really appreciate this. This webinar has been recorded. It'll be posted to the APS TARC YouTube channel probably within 1-2 weeks after we get our captions sorted out, and you can view it, and we'll notify you when it's posted live. So again, thanks to our presenters today for all the information. Thanks to all of you for attending, and we hope you have a great rest of your week. Take care, everyone.